overcome the fear inside you. Mr. Ray Chan.
主席，我根據議事規則第40條第4款動議，就2014年版權修訂條例草案全體委員會。
In accordance with RoP 40(4), I move that the Copyright Amendment Bill 2014, the debate be adjourned. In fact, in the committee stage, a member has already moved on the 28th of January a motion to adjourn the debate. It was made by Mr. Wong Yok Man. And at that time, Mr. Wong, he discussed with you that during the committee stage of a bill whether we can have a second motion to adjourn the debate. Because as far as I know, in the past, there has not been the moving of more than one adjournment motion during the committee stage in Council. At that time, the President quoted from the Hansard of the 16th of May 2012, and I quote, "Your understanding is that during the committee stage, there can be more than one motion to adjourn the debate, but it must be considered by the chairman of the committee to see whether it should be approved. And when such consideration is made, it depends on the last debate on the bill. And then when another member mentions a second motion, he has to consider whether a new scenario has emerged so that members will have another view of an adjournment motion. That is why at the House Committee last Friday, I asked a question on a point of order. I said during the committee stage, if I should seek to move a motion to adjourn the debate again, would the chairman approve it? The crux of the matter is whether a new scenario has emerged. What is that new scenario, Mr. Chairman? It is that Mr. Greg So, Secretary, after the aborted meeting on Wednesday, he said publicly on Thursday, and I quote him, that the Legislative Council will continue the scrutiny of the bill next week. Considering that before the end of this session, the Legislative Council still has to deal with the vote on account motion and also the appropriation bill and over 20 bills which are related to the economy and livelihood of the people. I will announce here that if next week the Legislative Council still cannot pass the bill, that will be the end of it because we have the big picture in mind. At that time, a reporter called me up asking me to respond. I said, that's the end of it. What is meant by that? And then another time, the secretary explained what he meant by that's the end of it. He said, if the Copyright Amendment Bill 2014 will not be concluded on Friday, then he will move an adjournment motion. At that time, I responded to the reporter that, impossible, I said. We only have 20-odd hours left. How is it possible to complete the 4 joint debates which are yet to be started? I said that he was only making a vague statement. I said there had been 7 meetings and 5 other meetings that were aborted, and altogether they only took care of half of the first debate on contract override. The secretary asked us to make haste to amend, and then still he said that's the end of it, well, meaning that he's giving up. He will not insist. That means when tomorrow comes and the bill is not passed, then he will move a motion to adjourn the debate. If the chairman approves the secretary's motion to adjourn, then he should also approve such a motion moved by a member. If colleagues will support a motion to adjourn moved by the Secretary, then theoretically and logically, you should also support and pass the motion to adjourn moved by myself today. I'm not here to preempt the Secretary. I said already that the Secretary should face up to reality, and when committee resumed on Wednesday, he should go ahead and move the motion to adjourn. I said to the media then, and I cited 3 reasons. The first one being that, indeed, on our order paper, there are many government bills that have to be processed. Even for these 2.5 days, on our agenda, apart from the copyright amendment bill, we have the bankruptcy amendment bill and also deposit protection bill, and also promotion of recycling and proper disposal of electrical and electronic appliances bill, and also the cleanliness in public places ordinance, and also property management amendment bill, and also government motions, and also members' bill motions on subsidiary legislation, and also Mr. Ng Leung Sing's and Miss Priscilla Leung's members' motions, and also Miss Claudia Mo's adjournment motion. If, Mr. Secretary, you know in your heart that within 20 hours it is not possible to tackle 4.5 joint debates plus the third reading plus the vote, then you should have moved the motion to adjourn as early as possible so as to free up more time for this Council to tackle the remaining bills. Today, Mrs. Carrie Lam sent a letter to you, Mr. President, that on the 16th of March, the administration would like to swap the items around on the order paper so that the Council would deal with the supplementary appropriation bill first. That will be the last meeting of Council in this financial year, and the administration will have to make sure that there will be the supplementary provision bill which will be supported so that there can be the necessary public funding for the government's work, including the public security payments. This is a very necessary and critical transitional measure, and I hope you will approve it. I believe, Mr. President, you will allow Mrs. Carrie Lam's request so that we can deal with the vote on account bill on the 16th, and we will cooperate. We will vote on the supplementary provisions bill. But Mr. Gregso, since the administration states that the schedule is so tight, and there are many more which are not on the order paper yet. Some have completed the Bills Committee stage, including the ICSO, the MPFO, and also other bills which are still at the Bills Committee stage. If that's the case, the Secretary should not issue the ultimatum only on Wednesday last. When a member moved a motion to adjourn the debate, he should have given it some active consideration. In the past, the Secretary might think that he had all the votes he needed. As long as the bill will be taken to offer a vote, he would always win. Here, I'd like to thank the chairman, because you said to the media, Chairman, that the bill is controversial. There should be sufficient time for members to debate. Setting a deadline is impractical. It is also unreasonable. This is a statement by the chairman, and it serves to tell you, Mr. Gregso, last Thursday you said that you would like us to pass the bill in these 2.5 days. I repeat what the chairman said. The bill is controversial. There should be sufficient time for members to debate it. Setting a deadline is impractical, nor is it reasonable. I thank you, Mr. Chairman, for defending our right to debate bills. Today, there had been 40 rounds of speech. Over 1/4 came from the pro-establishment camp. Even the loyalists felt that they had wanted enough time to debate on contract override, which is only the first joint debate. They also had wanted enough time to debate it. A member said to me, I have also prepared a lot of material on fair use. Can you not conclude this debate so that I can go into fair use? In other words, there are just 6 amendments on the first debate, which is contract override, and yet we had spent so much time on it. Therefore, in the past, you ended the filibuster on the appropriation bill, meaning you would limit the time on the 5 joint debates, like 10 hours for one, 20 hours for another. But you are not doing it this time because, Chairman, in the past, you only had to deal with a few filibustering members who would repeatedly speak in council, maybe for 8 times, 10 times. But what happens this time around? In the first debate, I have only spoken thrice. I, of course, can carry on till the umpteenth time. Mr. Chairman, Mr. Ng Leung Sing has been disturbing me. Members, order, please. When a member speaks, other members, please remain quiet. Chairman, amongst the pro-establishment camp members, you are the most sensible. You know this is a controversial bill which should be debated. Those from the pro-establishment camp who have spoken today have told us through their action that the bill should be debated. In fact, the secretary is getting personal here. Is there a way out for the bill? The secretary says by 1 p.m. tomorrow, if the bill cannot be concluded, then that's the end of it. Well, in fact, by 1 p.m. tomorrow, not even this adjournment debate can be concluded. We have had this bill with us for 3 months, since December. I believe the Bills Committee members have been with this bill for 1.5 years. I know they want to conclude the bill, and pro-establishment camp members can, of course, criticize us, and we can criticize the secretary. But still, you need to give enough time for members to express their views. I asked the secretary, you said you would move a motion to adjourn tomorrow. At what time? At 1:45? 12:30? And then after you have spoken, you hurl criticisms at us, and then we should only put it to a vote because we will have no time to speak? That's impossible. If you move the motion to adjourn at 12:30 and 1:45, do you want members not to speak, or do you want members to speak until the 16th of March? Or will there be other arrangements? We don't know. Reporters have been asking around. They say there are many possibilities. Maybe this will be put to the end of the order paper. I don't know. But after I've moved this motion today, there will be many possibilities. Maybe at the vote, the loyalists would vote against it. But if it is moved by you, Mr. Secretary, if the debate goes on to 12 o'clock and then they vote against it and then you move it, then they would support it. This is why I'm saying if you move it, then you have the big picture in mind and you are doing everything to help. But then if I move it, I am throwing a spanner in the works. I'm sure you will tell the reporters the same thing. In the last minute, well, I know I have another 15 minutes to reply. I hope you will look forward and go forward. We had the 4-party meeting. Mr. Dennis Kwok, Mr. Kenneth Leung, and Mr. Charles Smock proposed an improvement. If every party can forge a consensus and the Liberal Party said it would support it, you can come back any time and revive the bill. And you don't have to throw your temper around to say you definitely won't return to it within the year. If the bill will stay as it is without accepting any amendments from members. If you do not accept open-ended exemptions, or what Mr. Dennis Kwok's proposal that is limited open-ended fair use, then you should never bring back the bill. Never.
Mr. Raymond Wong once moved a motion to adjourn. There was a debate and was voted on while we were in the committee stage, and Mr. Wong's motion has been negatived. Now, Mr. Ray Chan would like to move a motion to adjourn again. I am satisfied with the arguments put forward by him. That is, since Mr. Raymond Wong's motion to adjourn has been vetoed, the debate within the committee stage has seen new developments. Therefore, I allow Mr. Ray Chan to move once again a motion to adjourn. Therefore, first of all, we need to deal with this motion. And for members who would like to speak, please press your button to speak. I now put forward the question to you. That is, the motion is we do adjourn in accordance with 45 of the rules of procedures. No amendment may be moved to this motion. Secretary, would you like to speak? Yes. Ultimately, Mr. Ray Chan is moving this motion. When we were in the antechamber, he appeared to be not having the courage to move it and have been pressing the government to do so. Now, eventually has taken the step. Now, last week, the government said that by Friday, by this week, if we haven't seen any substantive progress, then I will invoke 44 and move a motion to adjourn so as to truncate the debate. Pan-Democrats are filibustering deliberately. They are trying to abort the meetings, and the progress has been very slow. And after we've moved into the committee stage, I think we haven't made any progress at all. All the time I've been hoping that the electrical will be pragmatic and be objective and fair in deliberating the proposal from us. However, the performance of the Pan-Democrats in the past few months, as well as the performance today, for our expectation that they will set aside political calculations and be sensible and come back and be practical, I think we have been disappointed. The Bar Association, the Law Society, and some newspapers in the recent past have openly appealed to the electrical to put the interests of Hong Kong as a whole as a priority, and electrical should be sensible and reasonable and pass the bill ASAP. Unfortunately, the Pan-Democrats would not want to come back to the right track. I find it most regrettable. The government and the pro-establishment camp have been making the final attempts. Now, Mr. Ray Chan is still moving a motion to adjourn. He is wasting our valuable time. He is preventing us having the last chance to attempt to pass the bill. Mr. Ray Chan, you don't need to be so afraid to move this motion. By filibustering, you are grabbing our neck for your motion to adjourn. Well, this is a knife, and you are stifling, you are killing this bill. You dare not do it because you don't want to be the murderer. You don't need to worry because the Pan-Democrats here are murderers like you trying to kill the bill. You are not alone. Well, the government has earlier on decided that if there is no substantive progress, they will move a motion to adjourn to terminate the debate. of course, would like to take the overall interest of Hong Kong into account. Pan-Democrats are filibustering all the time. The normal operation of the LegCo has been interrupted. Dozens of government motions and bills have been prevented from being handled. As we all know that there are only less than 5 months' time before the end of the session. Other than copyright amendment bill, I think altogether we have as many as 27 bills to be enacted, including the vote on account bill as well as the appropriation bill. It covers a wide range of social, economic, and livelihood issues. In order to prevent the Pan-Democrats using this as an excuse to filibuster, jeopardizing other important bills, the government has to make such a decision, bearing in mind the overall interests of the public. Last week, we set a deadline for the bill. Some Pan-Democrats accused the government of being emotional, saying that the government shouldn't give up the bill at this stage. In fact, on the internet, there were certain comments saying that the government has got ulterior motives. In relation to such a feedback, in the ears of the supporters of copyright bill, well, it has only brought tears to them. Well, I think words may not be always accurate. We need to look at the figures. Since the 9th of December last year, we have had 8 meetings. Among them, 5 have been aborted. For People's Power, there is Mr. Chen and his colleague, Mr. Lee Cheuk-yen, Helena Wong, Gary Fan, and also Mr. Lam Kwok-hong and Mr. Raymond Wong in this chamber have more than once stated clearly that they would like to filibuster so as to obstruct the bill. For other Pan-Democrats, for those who are familiar with the bill, they have been very keen in speaking up. And for others who haven't been paying attention to the bill, very strangely have become very keen in joining the debate, and they have been proud of themselves for taking part in the filibustering. Sid Ho would like to start a precedent, and he would like to invoke Rule 55(1) of the Rules of Procedure to send it to a select committee to deal with the bill. Altogether, 90 hours have been spent and wasted on this bill. Now, for the Pan-Democrats, they have been using the quorum call mechanism, and they have also tried to seek an adjournment, and they would like to waste time by suggesting that the bill should be referred to a select committee. They've successfully wasted 62 hours' time. In other words, we've only got 28 hours on substantive discussion. All such figures show that the bill doesn't please the Pan-Democrats. Therefore, at all costs, they would like to abuse all sorts of rules and procedures, as well as the rules here. What is most mind-boggling is that some Pan-Democrats, after the government has made an announcement about the deadline, have strangely treasure the draconian bill and accuse the government of prematurely giving up. Well, there are just a few months to go before the end of this term. We cannot pass the bill. We cannot just try to pass the bill at the expense of all other work. Now, the external environment is in a poor shape. There are still a lot of livelihood issues in the society that we need to resolve. We cannot just allow endless time and limitless resources to be spent on political bickering. I think it is right for us to bring an end to the discussion of the bill, and it is with reluctance that we do so. Yes, it is regrettable to abandon the bill. First of all, the bill can bring about safeguards and benefits to different stakeholders. For copyright owners in a digital environment, they will get certainty and clarity in terms of copyright protection. They won't be affected by large-scale streaming by way of economic damages. And then for the OSPs, they're able to get exemptions from the cash arrangements, and then their daily operations will be safeguarded. They will not be accused of infringement. For the copyright users, there will be altogether over 60 exceptions. On top of that, parody, caricature, prestige, and parody, commenting on current affairs, quotations, etc., are additional exceptions. For secondary creation, it means that there will be a safe haven mechanism, and then they will not be affected. For the educational sector and libraries, again, they do have the exception. So because they are transferring knowledge and they have the communication right. And the copyright bill will update our regime, and then we are more in line with the international practices, and we can deal with large-scale rampant infringement of copyright like streaming. I think this is good for the business of Hong Kong. It will promote creative industries and ancillary industries in Hong Kong, driving the economic development as a whole. We have already noticed that some copyright owners are lobbying the U.S. government. That is, without this bill in Hong Kong, Hong Kong should be included in the special watch list under 301. Of 2016. We know very clearly that the users, in relation to their freedom of expression and freedom of creativity, they're most concerned about that. And time and again, we have explained that for the additional exceptions, they can cover the commonly seen secondary creation, and there's no need for the 3 additional amendments. Freedom of expression and freedom of creation will be much protected. As you may notice that on the 17th of February this year, the Bar Association produced a position paper that in support of the speedy enactment of the bill, with the inclusion of broader and more exceptions. The scope of exceptions are already broader than those adopted in other jurisdictions, and there is a higher degree of certainty. Say, for example, in the UK, they don't accept commentary on current affairs, and they don't include the purpose of satire. And even for the Australian model, they haven't included the exception for commenting on current affairs. Therefore, the bill can all the more protect secondary creation and also the freedom to comment on political issues. The Law Society, as well as an expert on IP law from the Hong Kong U, and from the Copyright Tribunal, we have Mr. Tong Tat Hei, Vice Chairman, as well as a former legislator, Mr. Ronnie Tong, and also a senior leader of the WIPO, have also made it clear openly that the proposals in the bill are legitimate and lawful, so that there will be adequate safeguards for the secondary creation authors. And then Charles Mock, Dennis Kwok, and even Ray Chen among the lawmakers, and even those who are against the bill, like the keyboard frontlines, have publicly said that when compared with the 2011 version, it is a major improvement. Giving up the bill is tantamount to giving up the chance to have benefits and giving up the chance to move forward. The bill, when not enacted, will also have this negative outcome. It shows that the consensus arrived at between the government and the stakeholders in the past decade, which is already a very mature arrangement, and will be wasted. It is not easy to come by. We have been starting on this since 2006. There were altogether 35 meetings of the Bills Committee. For members who are here, I'm sure you recall that in 2011, there was the Copyright Amendment Bill. We were not able to agree on giving exception to parody, and as a result, the bill lapsed with the ending of the term. When we restarted our legislative work, as usual, we have been adopting the usual arrangement, that is, we've been liaising with the stakeholders. We took the initiative to come into contact with the internet users. We'd like to listen to them directly. Whoever is interested to exchange views from us, whether individuals or groups, We have been most happy to meet with them. And since 2013, we have had meetings with netizens and groups for 40 times, and we've attended more than 10 forums, and we've talked about the details. And we have been responsive to their suggestions, and we have been trying to improve the bill. In fact, we have been sending out the message of having the maximum goodwill. We don't intend to be complacent, and we know that we may be coming to an end of this exercise. Now, nothing will come out of it. It will be futile, but I believe that we have already followed the normal procedures.
This has been discussed in a panel and it's been vetted by the Bills Committee. However, in the end, in the council meeting, it's been dragged and ground to a halt. And I do think that we have to think about the reasons why. What's most regrettable is the filibustering of Pan Democrats. They have deprived the opportunity of the committee for a full discussion. Some of the things said by Pan Democrats are not rational analysis. Some Pan Democrats said that the reason for opposing is because it's lopsided towards conglomerates, and they have it's done at the expense of the general public, and even if you use your mobile phone, you may be prosecuted. We have explained repeatedly. In the copyright realm, we protect public interest. We strike the rights between users and copyright owners. We safeguard public interest. The current bill does not tip towards copyright owners, and it has not criminalized our everyday lives. The additional exemptions and also the criminal liability threshold has brought more certainty. Ms. Winnie Tam, the chairman of the Bar Association, and Professor Lee of the Hong Kong U, both experts on intellectual property, have openly explained about misunderstanding of copyright. However, the species argument of Pan Democrats is still heard here. I don't know whether the members refuse to believe the government, the analysis of experts, or they already have their stance, so they turn a deaf ear to everything else. In any event, I am responsible for the Policy Bureau for this bill. We have to seize every opportunity to clarify the legislative intent, to clear any misunderstanding. In the second reading resumption, I have outlined the government's stance on the 3 amendments and the reasons for opposing them. A lot of time has been spent on filibustering and frivolous argument. The government members for or against this bill cannot elaborate on our arguments. But I'd like to say that, the government opposed to the introduction of open-end exemption and also the contract override limiting provisions at the last minute because they haven't gone through consultation or policy analysis. It is not in line with procedural justice. The amenders refused to budge. Mr. Charles Mock said that the government's doing everything we're doing for political reasons and therefore are against Pan Democrats' amendments. I think it's borderlining on misleading and is not justified at all. We have not concealed anything. We have submitted papers to the Bills Committee to give clear explanation. Before the second reading debate, there has not been any pan-democrats saying that if the government do not accept the 3 amendments, then they will filibuster to ground this bill to a halt. And when it comes to amendments related to the limiting provisions of contract override, we need to further analyze it, because freedom of contract it's fundamental to Hong Kong, is the cornerstones of Hong Kong's free economy or market. Copyright owners and users should be allowed to negotiate the terms of the use of copyright works. It gives them certainty, flexibility, and it also facilitates copyright owners to use copyright works in a more competitive way. It benefits both sides. And then the parties to a contract are bound by the contract, but no one else. What's more important is that there is no evidence showing that existing exemptions and proposed exemptions will be diminished in effectiveness because of the contract override. And these limiting provisions will only be added to some parts of the bill, and it is not ideal because, in effect, this has put the exemptions to different categories. There is no convincing argument. If it's just the introduction of limiting provisions to certain exemptions, there might be consequences that is unexpected. Perhaps, some other provisions will be overridden. The Bar Association and the Law Society have issued their position papers elaborating on their points. Well, members here who have legal training should read it again. On the 30th of January, and sent a letter to the LegCo, and last year in December, they have also sent a letter to the bills to the LegCo, and they are of the view that before consulting stakeholders and before taking reference of overseas developments, that there should not be legislation for contract override limiting provisions. On the 17th of February, in the position paper of the Bar Association, they said, after looking at overseas experience, well, there are merits of the limiting provisions, but we still need to consider it further because there is no experience to be drawn from. And there is also no evidence showing that contract override will affect exemptions. Well, with the existing exemptions and the new ones, it will cover common secondary creations on the Internet. We have clarification. We also have safe harbor and the use of civil litigation. This will sufficiently protect freedom of expression and freedom to create. Fair use will cause a fundamental change in our copyright regime. Back in 2004 and 2005, we have consulted the public about fair use. We've balanced all the views. The conclusion was that with clarity in the exemptions, this will reduce chance of litigation. Democrats proposed fair use is not our focus. And there has been insufficient discussion on this matter. For those countries who have accepted fair use, they at the same time have put in place compensation for an infringement to balance the interest and rights of both sides. Fair use needs to be further explored. Any decision will have to be based on evidence, and after sufficient consultation, we have to strike a balance. We look at other overseas jurisdictions. When it comes to the use of fair use, Well, in the UK, there has been 2 rounds of discussion. In Australia, back in 1980, 2000, 2004, 2014, 4 times considered this. At the end of last year, they have started a review and study. For the 2 countries, they have not yet legislated for fair use. The latest review of copyright of the EU, this is one of the issues to be explored. Hong Kong has an excellent system. We take into account society's need. There will be consultation, there will be collection of views and evidence before decisions are made, and then the legislative proposal will be introduced into the Legislative Council. There will be Bills Committee set up. Relevant bodies will be invited to express their views. At the end of the work of the Bills Committee, it will be debated in the Council. Members and the government may introduce amendments. It's the LegCo which decides whether to pass the bill. When it comes to sensitive issues, when there are strong views from stakeholders, this system is especially important. This ensures that the legislature and the executive will not just listen to one side, and the interest of society will be taken on board. Procedural justice is very important. We have to go through public consultation for everyone, different stakeholders, to express their views. This is in line with procedural justice, and also in line with overseas jurisdictions that have got a very mature legal system. And as I've said, at this stage the government cannot accept the 3 amendments because they have not gone through proper procedures. Copyright owners have proposed a lot of demands, say for example hyperlink and various proposals, and they have not been incorporated. Then how can we introduce the amendments without going through consultation? Mr. Charles Mok, Mr. Dennis Kwok and Mr. Kenneth Leung proposed something new on Monday. The government will have to exercise caution when it comes to new proposals, and there should be sufficient discussions in society. And the most important thing is consensus. On the 27th of February, the Bar Association said in its position paper that further exemption to allow users to create new work will undermine the rights of copyright owners, and there should be further discussions. Since there is no consensus from copyright owners, and it is simply unreasonable to introduce a reform without the consensus. Amendments should be based on consensus amongst stakeholders. In the 11th hour, the Democrats have gone back on the consensus forged. They want to introduce new amendments. They expect us to convince the copyright owners. And I think the word used by the Bar Association, that they've hijacked the exercise, is very apt. The bill has been introduced to the LegCo. It's been vetted by the Bills Committee. The Bills Committee comprised members from different parties, with 16 meetings and also over 24 meetings and over 50 hours, over 16 months. Well, I have outlined this because it's been 10 years, numerous rounds of public consultation, and at one point it was supported by most Pan-Democrats. In the end, it's not passed. How do we expect that the new proposal will see a miracle in the coming few weeks? Well, the Hong Kong, the Copyright Alliance have got over 1,400 members, and they have openly said they are opposed to the proposal.
At the very end of the scrutiny of the bill, meaning the committee stage, the Pan-Democrats are saying they are proposing something that everybody can accept. That is misleading. They are resorting to immoral means like filibustering. You are hijacking the council, and you are threatening that you should be the ones dictating how the bill should be passed. I think this is very unfair because you have tilted the balance to your side. And secondly, the so-called proposal has been drafted without a lot of thought and giving consideration to the intellectual property systems in the world. This cannot hold water. And also, you talk about limited fair use, but then in your drafted provisions, you don't use this crucial word, fair. The wording you used was dealing, not use. And number 3, the new proposal is similar in concept to what we proposed, but then we took it up with the copyright sector. It told us that at this stage, introducing any exemption under fair use, including so-called limited fair use, it would be worried and it would not accept it because there is no complementary package to protect copyright, and it has not been the subject of thorough discussion. They would like to stick to the consensus that has been reached, and they wouldn't like to break the balance that has been struck, and they say it is very unfair for them to be cornered. The proposals by the Democrats cannot take care of the worries of the copyright sector. Without a consensus, without sufficient discussion and research, the administration thinks we should not accept the proposal by Pan-Democrats. This is not where the public interest lies. At the end, I must point out that the Copyright Amendment Bill 2014 is ripe. It represents a balanced proposal. It does not need the Pan-Democrats' 3 proposals, and it has given protection to the freedom of expression and while protecting copyright. It has also been supported by the Law Society and Bar Association. Very often when you spoke, Pan-Democrats also admitted that this is a political issue that you are dealing in. Last Friday, I said in public, sorry, you're not coming through.
係第一，而家已經係8點鐘。第二呢，聽日個會呢，我哋一定係會繼續嘅。我宣布會議。
The meeting is adjourned now and will resume at 9 o'clock tomorrow morning.